When a person passes away, a lifetime of hard work, the house, the savings, the land, is left behind. The question is, who steps in to decide exactly what happens to all of it? The individual who built that life, or the state? If you die without a valid will, you die what the law calls intestate. In Ghana, that means the state automatically takes control of distributing your assets, applying a strict set of default rules known as the Intestate Succession Law, or PNDCL 111. PNDCL 111 does offer some immediate baseline protections, like preventing a surviving spouse or child from being ejected from the primary family home. But for everything else in the estate, it applies a rigid mathematical formula that leaves no room for personal wishes. This chart shows exactly how the state divides the remaining property. A surviving spouse receives 3/16. Surviving children get 9/16. 1/8 goes to surviving parents, and the final eighth is allocated according to customary law. That formula applies uniformly, regardless of your actual family dynamics. If one child needs more medical support, or if an elderly parent requires a larger share to survive, the state doesn't adjust. This blind division frequently leads to bitter disputes, tearing a family apart over property. Relying on intestate succession hands your legacy over to a game of legal chance. It completely silences you right at the moment your family needs your guidance the most. You can override that default system by legally establishing your own choices, using the Wills Act of 1971. To make a valid will, you must be at least 18 years old, of sound mind, and the document must be in writing. Let's look at a hypothetical example. Suppose Kwame Mensah owns a family home in Adenta, a vacant plot in Kasawa, and holds 2 active bank accounts. He wants to decide exactly who gets what. First, Kwame needs to name executors in his document. These are trusted individuals, like his brother or his eldest daughter, who are legally authorized to step in, manage his estate, and ensure his written instructions are followed exactly as he intended. Execution is critical. Kwame must physically sign his will in the continuous presence of at least 2 witnesses at the exact same time. But beware a devastating mistake. Under Ghanaian law, if a beneficiary signs as a witness, they legally void their own inheritance. Drafting a will requires precise adherence to these specific rules. Doing it correctly guarantees that your personal choices permanently replace the state's default fractions. Meeting these strict legal requirements doesn't have to be a complicated or expensive ordeal. Tools like the Ghana Online Willmaker, or GAUM, are designed to guide you through this. The platform uses a step-by-step digital process to ensure your drafted document strictly aligns with proper Ghanaian legal formatting. But a digital file isn't enough. You must print the document out. Once it is physically on paper, you must sign it in the real world alongside your chosen non-beneficiary witnesses to make it legally binding. After it's signed, seal the document and physically deposit it at the High Court for safe custody. This final step protects the physical document from being lost or tampered with, ensuring it can be easily located when the time comes. Keep in mind, this is an educational guide. If your estate is highly complex, or if you anticipate major family disputes, you should consult with a qualified legal professional for personalized counsel. Completing a legally sound will is the ultimate act of family protection. It shifts your family's legacy away from the burden of legal chance, leaving them instead with the clarity of your deliberate choice.